And everyone just give me a moment. Everyone, please make sure you're muted.
How do we have to do it one at a time?
Yeah, everyone, make sure you're muted, please. All right, everyone, welcome to the 187th District Court. You are physically in a courtroom. These are the rules of the 187th District Court. One, it's a courtroom. No matter where you're zooming at, you need to treat it as though it's a courtroom. Whatever you could not do if you were physically in the courtroom, you cannot do on the Zoom screen. What that means is there is to be no driving while zooming. No one here wants to be a witness to any accident, and we're trying to save lives, so do not do that. To all the inmates at the jail, you're not allowed to use the chat box. If you use the chat box, you will be sent back. No one is allowed to pick up dates. I know you asked yourself, why would I say that? Because people have tried that. This is not The Bachelor. This is not The Bachelorette. So do not do that. We have jury trial. Jury trial is starting at 10. So we are going to stop the Zoom at 9:45. I'm going to open up the breakout rooms. When I do, I'll invite you to a breakout room. Do not go to a breakout room unless I specifically assign you and call you by name to a breakout room. I'm going to take up the compliance hearings after I'm able to assign attorneys to a breakout room. John Fox, you're here?
Yes, Judge. I'm here on Antoinette Garnica. From the a lot can happen in a weekend file. We were set to do potential plea today. However, Ms. Garnica was arrested on 2 new felonies this weekend. So she is currently in the Bexar County Jail. When I looked it up on the computer, it shows her as released, but however, I think that's premature. I just talked to her family and she is not released. There seem to be ample bond conditions on her, GPS, house arrest, and things like that that are going to be in place. That may be what the delay is. So I'm unfortunately not able to get her here to appear in front of you, but I don't even think Marcus knows about this. I just kind of found out about it myself.
I did not know.
All right, Norma, on Antoinette Garnica, can you recall that for tomorrow? Are you available tomorrow, Mr. Fox?
Well, Judge, she's got the 2 new felonies that I don't represent her on and probably will not. It would be my estimation. I think the date is 7/20 that she set for pre-indictment. At least that's what's on the computer for those cases, even though she's not released.
Okay.
If you want me to sign on in the morning, I can. I don't know where she'll be.
What's going to end up happening is I'm going to receive a violation report, most likely, on
Yes, ma'am.
the new cases. So
Right.
I don't know if you want to address
I just
those
don't
or
know.
not.
Well, I'm assuming I'd ask you to do nothing on the bond for this case because I think there's ample bond conditions from safety aspect. My understanding is that one of the new charges is an additional aggravated assault with a deadly weapon, which is the offense that I represent her on, and the other one I think is a family violence second, if I'm not mistaken, which may be sort of a double dip. It may be all the same incident, just with 2 charges.
All right. So
but I don't know whether if she'll be out tomorrow. I don't know. She may still be stuck in there tomorrow.
when are the new cases set?
7:20 was what I thought I saw on the computer.
All right, Norman, can you just recall this case for 7:20 then?
Yes, ma'am.
All right, we'll recall it for 7:20.
By then, we may know what's going on.
Yes.
All right, thank you, Judge.
Thank you. And if you have nothing else with this, then you are excused.
All right, thank you.
You're welcome. All right, and then my understanding there are some people here from compliance hearings. Let me see. All right, Veronica Hernandez, you need to unmute yourself. Ms. Hernandez,
Yes, ma'am.
all right, we have some issues with you. What do you think those issues are?
I was testing positive on my drug test.
All right, why are you using drugs?
Um,
Well, let me help you with that. Do you want to go to prison?
no, ma'am.
Then why are you acting as though you want to go to prison by continuing to use drugs? That's my question for you. Why do you want to go to prison? Answer, why do you want to go to prison?
I don't want to go to prison.
You're behaving as though you want to go to prison. If you're tested today, what are the results going to be?
Positive. My levels are going down.
Yeah, they've been going down, going up. So when's the last time you used? And you better be honest with me.
It's been a couple weeks.
All right. And so what that means is you've been on probation since January 4th, which means you've been using since you're on probation. You're on deferred adjudication for abandoning a child with intent to return. You have not done your parenting classes. And I think part of your problem is that your mother, you're living with your mom still, is that correct?
Yes, ma'am.
And your mother is doing the heavy lifting. And the only thing you're doing is not doing what you're supposed to be doing on probation, acting like you have no responsibilities. So let me explain something to you. You have responsibilities to this court because you signed a contract. You have responsibilities to your mother because she's your mother. She's not your child's mother. Do you understand?
Yes, ma'am.
If you don't sign up for parenting classes and start completing that, we're going to have a problem. Do you understand?
Yes, ma'am.
If you don't stop using drugs, we're going to have a problem. Do you understand?
Yes, ma'am.
And where are you on enrolling in school or starting college? Where are you on that?
I'll meet with an advisor this week to see like what I need to pay for the classes and what I need to do to enroll.
All right, Rebecca, this is what we're going to do with her. I'm going to take note that I've admonished her about her drug use, admonished her to start parenting classes. We'll alternate amend, let her do the UA hotline, and we'll go with her that way. Those levels had better go down. You better not be using again, because the next time you use, I'm going to receive a violation report. And let me just tell you what happens when I receive a violation report. I'm given options. One of the options, alternate amend. The other option is to file a motion to revoke. What happens when a motion to revoke is filed against you If I think that it's legally presented, I sign it. You get arrested, you go to the Bexar County Jail. Somebody can bond you out or not bond you out. And then we have a hearing on your case. If the state proves the allegations in the motion and I find it true, then the next option is for me either to send you to prison or not send you to prison. And let me tell you, sometimes the state and the defense work out an agreement where they agree that the person doesn't go to prison. But guess what? I don't have to follow that.
Yes,
So
ma'am.
you had better start getting your act together. You're a mother. I don't care if you're 18, 19, your mom. Your mother is your child's grandmother. She's not the mother. And you had better start behaving and step up to the plate and do what you need to do. Do you understand?
Yes, ma'am.
All right, I'm sending you to breakout room number 1. You're going to wait there until probation gets there. All right, where's Maurice Wordlaw? Maurice Wordlaw.
Judge, he's under Monica Rubalcaba. I'm the probation officer. We're sharing a camera. He's the gentleman
Okay.
here in the yellow.
All right, can he speak up?
Yes, yes, ma'am.
Why are you here before me?
To see if I can get some better help with mental health issues, because medicine's not working here, and then it cannot provide the kind of help that I need.
All right, so probation, what are we going to do with him? Is there, can he be referred to the felony mental health court?
I did a little bit of inquiring to try to find some information regarding the felony mental health court. I haven't been successful with finding any existing program.
All
We
right,
also
are you,
have I'm sorry, Judge. We also have a nurse practitioner, Wardell Hollis here, who has shared his ability to also assist with potentially placement in SASH, if that would be something that might be.
all right, Mr. Wordlaw?
Yes, ma'am.
All right, I want you to be an active participant in your treatment. Do you want to try SASH or would you like to try felony mental health court?
I'd like to try SASH.
Okay, and do you understand what that entails?
Yeah. No, I don't understand what is in it.
All right, so that means that with SASH, you may have to go inpatient at a
Okay.
hospital. Is that what you want to do?
Yes. What's the other option?
I mean, we could have, see if probation can call the court coordinator for the 379th District Court. Probation, did you try calling the 379th Court coordinator?
No, I can try that. I reached out to the probation liaison manager to get some better guidance, and the information I received was that it didn't exist.
There's no funding at this time, Judge.
I'll go to SASH then.
Part of the concern for Mr. Wordlaw is that he doesn't have a stable place to stay if the time came for him to leave.
Okay. All right. Well, this is what I'll do. Mr. Wordlaw, since you want to go to SASH, I'll have you go to SASH, but I'm going to, normally, if we can have this set every 20 days, just so I can get an update on Mr. Wordlaw at SASH. I don't want him to be lost in the system.
Yes, Judge.
So when would be the next date we come back?
We are available anytime to return. I guess it would just depend on how soon the placement would be able to occur with SASH.
Yeah.
Mhm.
We're going to find out. Norma, what time do you?
I can bring it back like on the 9th of July, if you'd like, or I can bring it back on the 14th.
All right, let me see. What page is he on?
He's on the recall, Judge.
All right, let's bring him back on the 19th. So Mr. Wordlaw, we're going to alter and amend your conditions for SASH, and we're going to bring you back on the 19th.
All right. Thank you.
And to the clerks in the back, I did not have the court's file on Maurice Wordlaw. Can I have that, please?
On my way, Judge.
I have
Thank
a question, Judge.
Yes.
I remember you did say too that I was supposed to be in Corella's court when Jennifer sent me to my office. That was
Mhm.
like a year ago.
Okay. Now, what ends up happening is Judge Carruthers courts, that's your initial court for
Yeah.
them to make sure your evaluations are done. So your evaluation has already been done. So this is just for me to check in with you to see how things are going. So I want to make sure that you're in the right placement, okay?
All right. Thank you.
Thank you, Mr. Wordlaw.
Thank you, Miss.
Have a good day, okay?
Yeah.
All right, where is Cody Mayfield? Cody Mayfield, I need you to unmute.
Yes, ma'am.
All right, Mr. Mayfield, what's going on in your world? Why are we here?
Well, I'm here because I'm having problems with my classes. The instructor of my class that I'm supposed to sign up for, he's not letting me. I don't understand why he's not letting me
Okay,
sign up
time
for
out,
my
time out.
class.
Number one,
He's-
time out. Number one, you need to find a stationary position and stop moving around. It's making me dizzy.
Oh, sorry.
So the report I'm receiving is that you've been exited from the Batterers Intervention and Prevention Program. And this will be your second time. So why are you being exited? And what they tell me is it's non-compliance. Now, I understand maybe people don't have money, so I'm not even going to address the financial obligations. But the problem with you is your attendance. Why are you not attending? Why are you not on time?
Okay, ma'am. When I got enlisted into my class, he wanted me to give him $100 up front instead of paying the regular $20 to enlist in the class. I told him I only had $40, and he goes, "Okay, you cannot do my class unless you bring the other 60 by tomorrow before 1 p.m." When that happened that same day, ma'am, I was sent to the hospital because I got attacked by a crowbar in my head, which I have currently stitches on the side
Okay,
of my
you're
head.
saying you got attacked by a crowbar. Was there someone on the other end of the crowbar? Because usually
Yes.
crowbars don't attack people on their own.
Yes, ma'am, there was.
And has a police report been filed?
Yes, ma'am, from Wilson County. Yes, ma'am.
Okay, so continue.
So if that incident wouldn't have happened and I wouldn't have got placed in a hospital, I would have made it on there on time, even if I would have had to borrow the money from my mother. But that incident happened. When and I got out of the hospital that day, I tried showing him the proof and everything happened and the release forms from my hospital. He was not hearing it at all. And I told him, "Sir, look, I'm trying. I mean, I came straight out of the hospital because I know how important this is. I don't want to be in trouble. I'm on a monitor right now currently for my classes. The other court put me on a
So Mr. Mayfield, let's get to
my classes.
Mr. Mayfield. Let's stop making excuses. Let's get to the crux of the problem. So they're saying they want $100 from you to start class. Is that correct?
Yes, ma'am.
When are you going to have that $100?
I get paid every Friday. I will have it by Friday.
All right.
But
So
Rebecca? Yeah, I'm sorry.
Yes. Rebecca. On
Yes,
Mr.
ma'am.
Mayfield, this is what we're going to do. He's going to re-enroll in the BIP course. And since you say you'll have that money by Friday, you need to be re-enrolled by Monday. Do not go out. I know it's fiesta. Do not go out fiesting. I know that's not a word. I'm making it up. Do not go out fiesting and spend that $100. You need to pay the BIP class. You understand?
Yes, ma'am.
And if you're drug tested today, what are the results going to be? And I need you to be honest with me because you will be drug tested today.
I will come up positive for marijuana.
And what else?
And for I don't know if I'm pretty sure my prescriptions are probably gonna come up, but probably for I don't know the name. I think it's benzo, my anxiety medicine
Here's
that I
the
take.
thing. I'm not talking about prescription drugs. I'm talking about what have you been taking other than your prescription drugs? And you need to be honest with me. None of this is being recorded. You're not going to be put in prison because you're telling me, but I need you to be honest with me.
I'm gonna come up most likely positive for opiates.
All right. And what else?
That's it, ma'am.
All right. So here's the thing, Mr. Mayfield. I understand sometimes when people are with their friends, maybe you get a free puff on a marijuana cigarette, but usually the other drugs, they don't give you that for free. So you need to start saving your money to pay for your batteries intervention program. Otherwise, you're going to find yourself at the prison. If the state files a motion to revoke, what will end up happening is I will review the motion. I will, if it's presented to me in a legal fashion, then what will end up happening is I may sign it, and then you will be arrested. You will go to the Bexar County Jail, and we will hear your case, or either you will bond out. Do you understand?
Yes, ma'am.
So you're going to have to get your life together, stop using drugs, and handle your business. Here's the thing. I understand when people have drug issues. I do. I'm giving you a chance. You have a chance right now on probation. Whatever you need help with, they're willing to help you with. If you got a drug problem, they'll help you with your drug problem. But you cannot just not take this seriously. Do you understand?
Yes, ma'am.
And you had better start getting your life together, taking stock in what's going on. Otherwise, you may find yourself in jail. You may find yourself in prison. Do you understand?
Yes, ma'am.
And I guarantee you, if you were doing what you were supposed to be doing, maybe you wouldn't have been in Wilson County or wherever you were when you say a metal pipe attacked you. Do you understand?
Yes, ma'am.
I don't want you to come back here again, for one, for drug use and for not joining the batter's intervention program. Do you understand?
Yes, ma'am.
And I can tell you right now, you know, I understand people have issues, but the tears, no, that's not working on me. You understand?
Yes, ma'am.
So, Rebecca, what we're going to do for Mr. Mason is he's going to be in the batter's intervention program by Monday. If he's not signed up by Monday, I want a motion to revoke file.
Yes, ma'am.
And we need to address his drug issues. So if he's not, he needs to be in intensive outpatient treatment.
Yes, ma'am.
And make sure they test for levels on his marijuana use.
Did you want to do the UA hotline?
Yes, please.
Okay.
All right, Rebecca, I'm going to send him to breakout room number 1. And if you could go there, please.
Yes, ma'am.
Mr. Mayfield, you need to go to breakout room number 1. Gary Churek. You're muted.
Yes, ma'am. Yes, ma'am.
Yes, who do you have?
I have a motion to modify bond on my client. Right now, he's on basically GPS and he can go pretty much anywhere he needs to go because he works contracting. He's all over the state. He has a business. So basically, Judge, at this point, and he also needs an MRI and a CAT scan on his head. He had an injury and they're telling him they cannot do it with the GPS bracelet. My position, Judge, is back in the day before COVID, we had people out on bond. They didn't have GPS. They reported. The courts are open now.
Who's your client?
Oh, Jose de Vasquez.
What's your client charged with?
I think aggravated sexual assault, a minor.
All right, I can tell you right now, I'm not going to remove a monitor on an aggravated sexual assault of a child.
Okay.
So what are the issues?
Would you court consider just location tracking on him? It's just difficult because he doesn't know when he's going to get off work. If they're on a project, they may be working, to the wee hours of the morning.
No, here's the issue. I received a report that Mr. Del Bosque is like, I want to go to the movies. I want to do all of this extra stuff, and that's an issue. Mr.
Okay.
Del Bosque, can you unmute for me, please?
Yes, ma'am.
Yes, so he was allowed to work, but when he said he wanted to do family outings, it turns out that he wants to go to the theater. He wants to move around and do this and do that. And I know some people don't believe in COVID, but honestly, we need to limit contact, and he's not supposed to, I'm assuming, I could be wrong, but I'm assuming that he's not supposed to be around children.
That is correct.
So, I mean, him going to a theater, that's an issue. So I allowed him to work, and I believe the state agreed that he was allowed to work. Joe Ray Garcia?
Yes, Judge.
Hi, I believe you all allowed Mr. Del Bosque to work. Is that correct?
Let me look up and see. I know this is David's case. He's on right now. I don't know if he's by his desk.
Oh, David Martin, are you there?
I'll pull it up if he's not.
Yeah, Judge, I don't think we had a problem with him going to work. I think that's why he's able to do whatever he needs to do.
All right. So, I mean, your client is able to work, but all of this, I'm going to the movies theater, I'm taking advantage of Fiesta. That's not going to happen. So is there another issue besides his being allowed to work?
The only other issue, Judge, is he needs a CAT scan MRI, and they said they cannot do it with the bracelet on him.
All right, then we can make sure that if he gives us the appointment for when his CAT scan is due, provide medical proof that he has a CAT scan that's ordered. I don't think anyone will deny him the right to have a CAT scan.
All right, Judge. Well, I think that's it then.
Okay. Well, just before you go, Mr. David Martin.
Yes.
I'm assuming you have no objection to Mr. Del Bosque receiving his CAT scan?
No, if he provides proof of when the appointment is and can arrange with pretrial services to get the monitor taken off for that and just go back and get it put back on when he's done.
Yes, so just provide that and we will make that happen.
All right, Judge. Thank you.
All right, thank you. All right, yes, you're excused. My understanding there are several attorneys in the courtroom. Who's the first attorney? Because I can't see that far. Step up, anyone.
And yes, stand back.
Hi.
Good morning,
Yes.
Judge. James Milan for Andre Monjares.
Yes.
So we have a deal worked out on this case. He has a co-defendant, his brother, which I think both cases are ready for a plea. I didn't know whether I was supposed to be on Zoom or in person. I never even received
Yes.
the notice.
Just do the paperwork
Okay.
and we will make that happen.
Okay. Thank you, Judge.
Thank you.
Is Tom Nisbet available? Because he's the one who's on the case.
Yes, Tom is available and he will get you the paperwork, and the court will note that I was informed by the brothers Monjares. That sounds like a traveling circus or something, but I was informed that the brothers Monjares had worked out an agreement, so that will be accepted.
Thank you, Judge.
All right. All right, who's next?
Good morning, Judge. Brenda La Paz, Charles Moore, page 9.
Yes.
Meredith was kind enough to call and advise that they're going to be dismissing the case. I don't know if you've gotten the dismissal yet.
That's
Oh, no,
correct,
as soon
Judge.
as, all right, as soon as I get the dismissal, that will be done. All right, since everybody's getting haircuts, since everything's open now.
I haven't got one yet. Are you making fun of me, Judge? I haven't
No,
got
I
one.
am not. I thought there was a haircut that blame it on my vision,
Okay, all right.
but it's a nice haircut if it is one.
All right.
All right, thank you for showing up. You and your, yes,
I was gonna ask, are we excused, John?
yes, you and your client are excused.
Thank you, Your Honor.
Thank you. Next attorney?
Yeah.
Good morning, Judge Patricia Vieta for Ramiro Cervantes.
All right, that's the case you asked for a continuance, correct?
Yes, Judge.
The court sent an email and had the court coordinator to send an email. I understand that you had medical appointments with your mom.
Yes.
I did grant that motion for continuance.
Okay, thank you, Judge. I hadn't received notice on that. Thank you.
Okay, I'm sorry about that, but you're excused. I hope your
Thank you,
mom
Judge.
gets better.
Thank you, Judge. I appreciate that.
Sure.
No, Judge, it was sent out on Friday evening.
Okay, all right, thank you. Todd McCray?
Good morning, Your Honor. Todd McCray, fresh from the barber shop with Denise Robles. Judge, I have a couple of motions on file that need to be heard, but before I proceed, I would like to have the state's announcement on this case since it's on a trial docket.
Yes. Yes, state's ready.
Judge, I have two documents that I filed over the weekend after we spent a lot of time going through numerous videos at the scene. One is a defendant's request for discovery of informant information. I do not believe that the state has complied with their duty to provide discovery in this case. I don't believe they've complied with 3914 of the Texas Rules of Criminal Evidence. I don't believe they've complied with the United States Constitution or the Texas Constitution under United States versus Bagley. And I believe they're also outside of the Texas Disciplinary Rules of Professional Conduct, Rule 3.04A, in that they have not provided me with the discovery I need to effectively cross-examine and confront the witnesses against Ms. Robles. So
Okay,
based
so-
on that, I'm not able to say that they have complied with their duty to provide discovery in this case.
So here's my question, counsel, and we're not on the record yet, but the court received, and I believe you were the attorney on the case, on April 18, 2019, the court received an acknowledgement of discovery that was signed.
Well, yes, Your Honor, and I'm acknowledging that I've received what they put in that document, but I'm not acknowledging that is sufficient to satisfy what I believe is their duty to provide discovery, which they have not provided.
So here's my question. Why am I just hearing about this today? Was this just learned about on Friday?
Effectively, it was, Your Honor. I have a motion to reveal the identity of a confidential informant. And I had communication last week from the district attorney's office whereby they represented that they believe that this informant, which is mentioned in the police report, but is not identified in the police report as an informant, that they have taken a look at some videos and they believe that the informant has waived the
All right,
privilege.
just one moment. We'll take care of your matter in 1 second. So
And
just
I
give me a
can speak
moment.
to that, Your Honor, later.
Yes. All right. So Mr. McCray, if you'll have a seat for me, we'll take care of that in just a moment. Who are the
Yes,
other attorneys in the courtroom?
Good morning, Judge. Jennifer Zarka and Amy Owen for Derek Garcia.
Yes. What is happening with Derek Garcia?
Defense is ready, Judge.
All right, state, are you ready on this case?
No, Judge, I'll be filing the dismissal now.
Thank you.
All righty.
Are we
You all
excused?
are excused. Yes. Well, you may want to wait until the court gets the dismissal, or either if you want to leave, you're free to leave. And I will let you know that when the court receives the dismissal, the court will sign it, and then you'll be able to pick it up probably this afternoon.
Yes, Judge. And just for the record, our client's here as well. So is he excused too?
Yes.
Thank you, Judge.
You're welcome. All right, who's the next attorney?
Good morning, Judge.
Good morning. Hi, Ken Baker. What are we doing with your client?
Judge, we're here. We're ready. My client is not here. I have had communication with him all weekend. And additionally called him this morning. He's where to be here and what to wear. He did say he's on his way.
All right, we will wait for your client. Just give us a moment.
Thank you, Judge.
All right, is there another attorney in the courtroom?
Last but not least, Judge.
Yes.
I'm here for Charles Bunk on behalf of Joshua Carroll. Actually, on my way over here, I received a phone call from Joshua Carroll's fiance stating that he has a fever of 103, which I told him, obviously, don't come. I don't think he'd be allowed in the building at this point. He is able to Zoom if the court wants him to, but I know he was set for trial today, so obviously that would pose a problem.
All right, let's have him Zoom in, or either if you want to, you can call your client, tell him if the court does not receive medical documentation, then he is not excused from appearing. So the court needs some sort of medical documentation that this is true.
And I think, Judge, what they were planning on doing is going to get him a COVID test. So I don't know if that would suffice to show that he went and got tested today, or if he needs, I don't know what to tell him.
I mean, if his fever is that high, I think it's a doctor's note. Otherwise, I don't know if we're dealing with a leave it to Beaver situation. I don't know, Kelly. Sometimes I reference series that are in my age category, but you remember that episode on Leave It to Beaver where he got a thermometer and he put it on his lamp, but he left it there too long. So his fever was like 200 and something degrees.
I'm pretty sure
Eddie Haskell told him to do that. So I need to make sure we don't have an Eddie Haskell moment going on. Okay. But if you can get that for the court, then of course the court will understand.
Okay, Judge. I will work on that right now.
All right, thank you. All right, is there another attorney in the courtroom? All right, so then Mr. Todd McCray. Meredith, were you the one who's going to speak with Mr. McCray?
Yes.
All right, Mr. McCray, I'm going to send the courtroom to breakout room number 2. If you could go there with ADA Meredith McIntyre, please. And I will check my email for any dismissals. And Mr. Baker, can you let us know when you have an update on Rudy RC, please?
There to chop down. I was telling the office for that.
All right, thank you. Sean Dawes,
Sorry, Your Honor. Yes, I'm here. I will need to confer with the state regarding Mr. Perez.
all right, who's conferring with Sean Dawes on Mr. Perez?
It would be family violence.
All right, I'll send you to breakout room number 1.
All right, thank you.
And I can talk to him.
All right, thank you. And Norma, can you see where David Garcia is to get these inmates taken care of, please?
Yes, sir.
Hello. Sure. Are you all back on Miss Robles?
Yes, Your Honor.
All right, what is happening with Miss Robles?
Well, at this point, Judge, I don't think we're seeing eye to eye on the outcome. It's my understanding that this is a dismissal or nothing type situation unless he needs more time to talk to his client. That's where the state is at this point. I don't necessarily agree with Todd's perception of our compliance and what we have provided and what he needs.
All right,
So I just
what's-
need to, I'm sorry, Your Honor.
No problem. So first then we'll take up the request for discovery on informant information unless defense, do you feel like you have all the discovery or are you saying that you need this other information?
I do not believe they've complied with 3914 or the Constitution in their duty to provide what I need to effectively confront and cross-examine the witnesses that I believe they intend to call.
Okay, just give me 1 second.
And that's the basis of my motion for continuance. And you will hear during this trial, Your Honor, if you deny my continuance and the state continues to represent that they believe they have complied with their discovery duties, you will hear this issue come up again at trial during the confrontation of these witnesses.
Oh, I mean, everybody can cross-examine and however they want to cross-examine, of course. What page is this on the docket?
Page 8.
All right, where's your client?
She's right here in the courtroom behind me. You want to raise your hand, Denise?
Okay, we'll have a hearing on this request for discovery. State, are you ready to proceed on the request for discovery?
Yes, Your Honor.
And so here's the question before we begin and before we go on the record. Defense, you're going to be saying that you just discovered this on Friday?
Yes, Your Honor, and I had a representation last week from the state that they acknowledged that one of their main eyewitnesses is in fact an informant. There's a brief conversation on a video where this informant is saying that he is an informant, but I first received an acknowledgement last week in response to my motion to discover the identity of the informant last week. So what I have done is filed a specific request for discovery of informant information, and that's on file. I filed that this morning. I've got a file stamp and I emailed a copy of that to the state.
Okay, so my question then is, like, your discovery of this was on a video that was given to you by the state, is that correct?
There is evidence of that on a video, yes.
Okay, so then, and we'll go on the record, but I'm just trying to wrap my mind around this issue. So you received a video where you say there is a person on there that you believe is the informant. When was that video turned over?
So that's been in the file all along, Your Honor. Here's the problem, Judge. I believe what's happening here is there's this, somehow this is being turned into, it's my duty to do something. I have no duty under Brady. I have no duty under 3914. I have no duty under Bagley. I have
But
no
here's
duty
my
under
question,
Bagley.
but do you have a duty if, this is what I'm trying to get to the point at. Was the video turned over to you? Like, I understand Brady, I understand Michael Morton, I understand that they want to call it to the Michael Morton Act, but what happened to Michael Morton has happened before the other people. And I don't know why the act wasn't named after them. I understand all that. But what I'm trying to figure is when you knew. Because we're here on this is wait, time out. We're going to go on the record, but this is why I'm trying to understand when you knew about something.
Sorry, I thought we were on the record.
The eighth setting, everybody's coming to me now with the motion when here we are at an eighth setting for jury trial with a jury in the basement waiting to hear a case. So I understand what the state's duty is, but my question is,
So
did you have the video? Did the state turn over that video? That's my
the point
question.
is, Judge, the point is not the discovery of the video. The discovery that I'm requesting is the material to confront and cross-examine witnesses that are not in the police report and the contract that this informant has with the state.
Counsel, I understand where you're going, but my question is, and I need somebody to answer it. Whoever wants to answer it can answer it.
I've answered it, Your Honor. It's
No,
in
no,
the
you have
file.
not. Did
It's
you have the
always been.
video? Have you reviewed the video? When did you review the
Yes.
video?
Yes.
Yes. And when did you review it? Was that video reviewed on Friday? Has it always been in the state's file? Because the information I'm getting from you, counsel, and I'm trying to figure out what's going on, the information I'm getting, it seems as though you're saying that the state had a video, that the first time you saw this video that the state had with this witness that you want them to reveal was on Friday. So I'm trying to discover if, state, maybe you can answer this question for me. The video, was that video always turned over to defense?
Yes, Your Honor, as well as the main officer's police report. It's an unusual case in that the informant is actually not confidential and has not been confidential. I did provide him a memo of disclosure on Friday as it relates to the criminal history of that individual, some of which we don't believe is admissible under 609, but in terms of conversations and what we turned over, that was additional on Friday.
Right. All right, so now I know where we are. So now we're going to go on the record. Can you have your client step forward, please? Court is calling 2018 CR 11674, State of Texas versus Denise Renee Robles. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense.
Todd McCray for Denise Robles.
All right, for the record, the defendant and the defense counsel are in the courtroom. The state is by Zoom. Any objections to us having this appearing by Zoom? State.
No, Your Honor.
Defense.
Judge, we're live in the courtroom.
But the court is by Zoom in chambers. Is there any objections to the court hearing this case while the court is in chambers?
No, Your Honor.
Any objection to the state being by Zoom?
We're in the courtroom, but no objection, Your Honor.
All
No
right.
objection from us.
Thank you. Ms. Robles, do you have any objections to the court hearing this case while the court is in chambers?
No, ma'am, no objection.
Do you have any objections to the state being in their office by video?
No, ma'am.
All right, so this is set for jury trial. Let's take up the defendant's first motion, which is a request for discovery of informant information. State, are you ready to respond to this motion?
Yes, Your Honor.
All right, defense, it's your motion. You may proceed.
Judge, I think the motion sets out the law that is appropriate in this case. I think the predicate has been laid in the motion in paragraph 4, application to the instant case, which addresses the question of the state revealing the identity of the confidential informant. I think the confidential informant in this case waived the privilege by admitting to being an informant on videotape during the investigation of this case. And you can see in paragraph 4, a review of the district attorney file to date has revealed that information provided by witness Joshua Macetta, who admits on videotape to being an informant for law enforcement, was used to initiate an investigation to detain without a warrant the defendant in this case. The same information was used to search and arrest the defendant and a vehicle. Joshua Macetta told the San Antonio police officers at the scene that he was a police informant and that his house, the scene in this case, had recently been raided by the police. Joshua Macetta told the arresting officers in this case that he is a member of a cartel. It is common knowledge that the San Antonio Police Department, the Bexar County Sheriff's Office, and the Bexar County District Attorney's Office and federal law enforcement enter into contracts with various persons under which charges against the CI will be dropped, reduced, or not filed at all for the confidential information provided implicating others in criminal activity. This is most common in drug cases in which the CI will often not only provide the information, but participate in the drug deals leading to arrests. In such cases, the jury should be permitted to hear and weigh such evidence in reaching a decision on the legality of the detention, arrest, and search. And so I am asking, Your Honor, because I don't believe they have provided me with details about the contract that this Joshua Masetta has with law enforcement. There are also numerous individuals that are arrested at the scene that are not identified in the police report. I believe that the state has a duty to provide this material. I believe the state has a duty also to provide the material about these other individuals that are not mentioned in the police report, and provide me with material to effectively cross-examine the witnesses that they call pertaining to those individuals that were at the scene and not mentioned in the police reports. Therefore, I believe the state of Texas has an affirmative duty to make timely disclosures of exculpatory or mitigating evidence under the Due Process Clause of the 14th Amendment to the United States Constitution. Council does not believe the state of Texas has complied with their duty under the United States Constitution. The Texas Constitution 3914 of the Texas Rules of Criminal Evidence, Brady, Bagley, or Rule 3.04A of the Texas Rules of Professional Conduct. Therefore, based on that, we're asking the court to continue this matter to allow the state to comply with those laws.
State?
Your Honor, the state feels as though we did provide, based on what has been in the file, the information that he would need. This is.
Oh, I'm sorry, you went out for us a little bit as far as on the
Okay.
volume.
I apologize. Can you hear me now, Your Honor?
Yes.
Your Honor, the state does feel that we have provided the information that he is looking for, in that he has known who that person was based on the report as well as the video. This is a unique situation in that our informant is not confidential. He's in the evidence that has already been provided. The state also provided criminal history of that individual. And based on the things that the state has already provided, we do believe we are in compliance with what defense is asking.
All right, defense?
Judge, I do not believe they've complied under the United States Constitution under the rules that I've cited. Where again, we're asking the court a continuance to allow them time to adequately respond.
I'm not gonna, we're gonna deal with this issue with the informant. I've read your motion and it appears you always knew that the person you were talking about was Joshua Masetta. And if it's something, you've informed the court that you've had this video. Did you, counsel, did you discover Joshua Masetta, M-A-S-E-D-A? Did you discover that person just on Friday?
Your Honor, that evidence has been in the file since we first received discovery a long time ago. The point that I'm asking for is impeachable material that have to do with contracts this individual has with law enforcement. That has not been provided to me.
Okay, so, but this is my question, because I want the record to be clear. This disc or video has been in the state's file. You've said that. My question is, when did you review the video that's in the state's file? Because the way the motion for continuance has been presented to the court is as if though this Joshua person, this is the first time that defense is hearing about it on Friday.
That's not what my motion says, Your Honor.
Okay, so you've known about this Joshua person for months. Is that correct?
Yes, Your Honor, it's been in the file and I've reviewed the discovery. So the issue is not that he's an informant. They just admitted to me that he is in fact an informant. I can't take his word for whether he's an informant or not. People lie all the time. They just told me last week that he is in fact an informant. That's the first time I learned that the state said in response to the motion that's been on file for a year, 2 years. I don't know the date of it, but that motion to reveal the identity of an informant has been on file for a long time. The state first responded to that last week. So, and what they said is, we don't believe we have to give it to you because it's not privileged anymore, because he's revealed it on the tape. So the point again is not that at this point we don't know that he's an informant. The point is that right now they haven't provided me with Giglio, Bagley, Brady, 3914 material to effectively cross-examine him about his relationship with law enforcement.
And I
And
think
that's what
the point is, why are we waiting for the 8th setting, the day of trial, and to say that we're just discovering this? That's
It's not my, yes,
I
Your
want
Honor,
to
because it's,
clarify-
may I respond to that?
Yes.
Because it's not my duty to provide this material, Your Honor. And so we're on the cusp of trial because they haven't provided me with this material. They have an affirmative duty, and the cases are cited. I don't have to ask for it. They are required to provide this material. And the reason we're bringing this up on the verge of trial is because they have not adequately responded to their duty, their affirmative duty to do this. I don't have to ask for this material. They have to provide it, and they haven't done it. And I'm raising it right now and letting the court know that I don't believe they've complied. And it's as simple as that, Judge.
Well, I mean,
Can I
before you
respond real quick?
I will let you respond, State. But here's the court's problem. We can say things are as simple as that, but the court is here Monday through Friday from 9 to 5. Everybody knew when this trial was set. And now I'm being told that you want certain information. Now everybody wants the court to interfere when this could have been presented to the court sooner than this. State, I'll hear your argument.
And Your Honor, just to give some context, I did call defense last week to clarify some issues, because according to our file, the defense wanted to know if Brandon Herrera was the CI. He's listed as a co-defendant in the report, which was confusing to me because, as I said before, unusually in this case, we have the CI in there. And so that is what I confirmed for him last week, was that the CI is not Brandon Herrera. He's a co-defendant. But again, we know the identity, and that's what I was confirming last week.
Okay, is there anything else from either side?
So just to kind of repeat what I've already said, Your Honor, if I may.
Yes.
I'm not, they have the duty. And for some reason, Your Honor, these discovery acknowledgements are being handled as if we had some duty to tell the court what the state is supposed to provide us with. And I don't believe the code is written that way. I don't believe our discovery acknowledgement forms are written that way. I don't think that's what Brady says. I don't think that's what Bagley says. I don't think that's what Giglio says. So I wait, and I'm waiting for the state to provide the material that I believe they have a duty to do. And the reason I'm raising this before trial is because I don't have it. And now they're saying they've complied with it, but I am saying I do not believe they have. And that's why I've filed the motion for continuance. And if later on we find that they did not comply with this, and my cross-examination and confrontation is ineffective as a result of them not providing what I believe they should have provided, then the error is in place. And that's why I filed this on the verge of trial, because I don't believe I have any duty whatsoever to turn over this material. I believe they do, and I believe they haven't done it. And I'm bringing it up at this point because.
And let me explain to everybody what the acknowledgement of discovery is. The acknowledgement of discovery is an acknowledgement that you've received all the discovery that you say you should receive. What these trial settings are about and what the plea deadline date is about is that you're saying you have everything. And for everyone who's set for trial, before you are given your trial date, I ask you if you have everything. To get information or then to wait till the last minute and say, aha, the state should have given me this and I don't want to have it and I don't have it. So now hear my motion for continuance. That's an issue.
May I respond, Your
That's
Honor?
what the issue is. The issue is people are coming to me with a request for a continuance saying, well, the state should have gave me this and they didn't have it. And now people come to the court at the last minute and say, can you make them give this to me now? When if people would have came to the court a week ago, 2 months ago, then we could have resolved this issue if the court believes there is an issue. Depends in your own motion for the informant information. You say you already know who the informant is.
May I respond?
So
Your Honor?
yeah, if you guys will step back, I'll make my ruling in a moment. Mr. Baker, is your client present?
Your Honor, he is not yet.
All right, just one moment.
The never-ending drive.
All right, has the paperwork been started on Manharis? Anyone?
Tom says
Working
he's
on it right now.
Okay,
Oh, is
all
it?
right, thank you.
Yes, Judge. Mr. Nisbet apparently is preparing the paperwork and is going to be sending it to us by email. He'd requested our email addresses.
Okay, and is James, do you know about Jose Manharis? Is Orlando?
They're both in here, and both Orlando and myself are awaiting the paperwork.
All right, thank you. All right, and Norma, can you find out where Mr. David Garcia, Eduardo Jimenez?
I already checked everyone. They said they're all in hearings and they're coming in just a few minutes, Judge, and I already told them.
All right, thank you.
Judge, and I just sent you a text message.
All right. All right, thank you.
You're welcome.
And I haven't actually gone. Promise me giving you something that's not.
No.
It's only-
No.
So this is everything except the photographs because the photographs. But I can just show you. If you have like,
You know, I have a
anything weird on there?
no. It's just my discovery.
Can you give me a virus?
No. I just want. Only thing I do is download discovery.
We were with you.
Yeah, go check it out. It's just my discovery. In fact, it may only be RC.
How does it feel?
Okay.
I don't think about this.
I refuse to plead guilty to something that I didn't do. I'm an innocent man. I want to go home. The girl's strung out on drugs. Try to help her get her kids back. The more I try to talk to her about responsibility and getting her kids back and getting a house.
John, put yourself on mute. Everyone can hear you.
Sean, can I get some time to think about this, please? Like the conversation you had with me, I'm just overwhelmed by it.
Excuse me.
Just
Excuse me. Just give me a moment.
He was talking to me. Let me get my Johnny sack.
All right. Sean Dawes.
yes, Your Honor. We conferred with the state, and as you just heard my client said, he wants a little bit more time to consider the offer.
No, today is his plea deadline date.
I know. There was an offer from him that I passed on to the state. State rejected. There was a counter offer. I presented it to him, and he wants to think about it some more. Last night, we went over a substantial amount of the videos. Of course, a lot of these videos are 4 hours in length. I was also there on Saturday too. And I know originally you had given me a date of the 25th, but that was during Rusty Duncan. If you can, if I could have like one last plea deadline date, maybe after 4th of July, so that I can.
I understand what you're saying, Mr. Dawes, but here's where the court is at. He was given a plea deadline date on May 13th. I extended it. And I extended it to today, and he was supposed to speak to whomever he wanted to speak to, because this was previously set on June 14th. So he was going to speak to whomever he needed to speak to, and he was going to come back and give me an answer. What I'm being told is that the state offer has not changed.
The number of years, yes.
Yeah, so it sounds to me as though, Mr. Perez, could you unmute yourself, please?
Good morning, Your Honor.
Good morning. So it sounds to me as Mr. Perez wants a jury trial and the court will give him a jury trial.
I haven't seen all the discovery, Your Honor. That's what we've been trying to. I've had 2 days with Sean Kings, and I asked him, I try to, explain to him, like, I know it's hours of video, and he flat out told me, like, I can't sit here and.
No, here's the thing. Nope, let's stop this. Don't put anything on your defense attorney, because I put everything in my docketing statement.
He had to leave.
And no. Here's the thing. You told the court that on May 28th, that you were gonna hire an attorney.
I tried.
So,
yes, Your Honor.
and then on May
And I couldn't
13th,
afford it.
you refused to come out of your cell. So that's where we were. May 13th, you refused to come out of your cell. It was reset for May 28th. May 28th, you say you're gonna hire an attorney. So here's the thing. Today is your plea deadline date. Mr. Dawes, if you want, I will recall this for Wednesday, but that is it.
This Wednesday, 2 days?
Yes. This case has been going on since March.
Thank you, Your Honor.
And well, but and honestly, well before March,
Thank you so
because
much for your lenience. Thank you for your understanding. Thank you for your patience.
no.
I'm sorry.
This has been going on well before March. Because the offense date is December 12th, 2020. And mind you, the court doesn't accept any of these allegations as true because I haven't received any evidence on these allegations. But what I'm saying is,
That's what I'm.
we will come back
Your Honor, I was trying to see the
on
discovery.
June
Because-
23rd.
John, stop.
We will come back on June 23rd, and on June 23rd, Mr. Dawes, that's the last plea deadline date the court is given. The court will not give any more. That means that you will be heading to the first available jury trial after June 23rd. Do you understand, Mr. Pettis?
Yes, Your Honor.
So whomever you want to talk to, whomever your attorney wants you to talk to, then you can go forth and do that. But on June 23rd, that is the last day.
Thank you, Your
Can I
Honor.
address the court, Your Honor?
Your
John, I'd
attorney
rather
may not
you
wish
not-
for you to address me.
Yes,
No?
I'd rather you not. I'll come see you, okay?
All right.
Just,
All right, thank you.
all right. Thank you,
This is
Judge.
my
May I be
life we're
excused?
talking about.
Yes.
I was trying to get some understanding of,
Okay, I will explain everything to you, John. Please don't say anything more, okay? I'll
Well,
come see-
Sean, just one moment. Let me let Mr. Pettis know. Mr. Pettis, from
Yes,
the
ma'am.
court's perspective, this is what you need to know.
yes,
June 23rd, either there will be a plea bargain agreement in some form, either it will be one that you've reached with the state, either it will be one that is open to the court. But on June 23rd, that will be the last day that the court will accept any plea bargain agreements. Do you understand?
clearly, Your Honor. I just want
All
to
right,
see the
thank
full
you.
discovery package, so I'm,
Thank you. Norman, can you let them know that number 12 can go back? Mr. Dawes, thank you.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
Brenda, today is Monday. It's not Tuesday, it's not Wednesday, it's not Thursday, it's Monday. Alfredo Ortiz, who are you here for? Hi, you're on mute.
Good morning, Your Honor.
Good morning, how's it going?
I read to my office. I didn't know there was a setting this morning.
Yes, your client, Mr. Talbot, is requesting a PR bond.
Okay.
So did you wish to just have a discuss with the state?
Yes, please.
All right, if there's a prosecutor available on Mr. Ortiz for Joshua Talbot. It's a criminal trial division. I'll see you to breakout room number 2.
Thank you, Your Honor.
You're welcome. Could a prosecutor from Criminal Trial Division go to breakout room number 2, please?
Judge, can you make me a co-host?
Yes. All right, Mr. David Garcia, I'm going to send you to breakout room number 1. Prosecutor will meet you there. If a family violence prosecutor, you could go to breakout room number 1, please.
Your Honor, can I be in a breakout room with Mr. Talbot?
Yes. Mr. Talbot, I'm going to send you to a breakout room number 3 with your attorney. Scott Martinez, who do you have?
Judge, he has an inmate Estrada, the female.
All right. What page is she on, Norma?
She should be on the first page, I think, or the second page, Judge. Well, hold on, give me 1 second. She's on the recall on the very top.
All right. All right, Mr. Martinez, that case is for 2 p.m. Have you conferred with the state?
I conferred with the state last setting. My client has medical reasons, and I wanted to get some proof and show it to the court that for why they should hopefully terminate on SAT and release you from jail. But
Okay, that's something you, no, I mean, is this going to be a contested motion to revoke or not? Because you're set at 2 for a contested motion to revoke.
Well, she's going to plead true, but we're contesting the punishment, I suppose, if that's contesting.
All right, then if I'll send you to a breakout room with the state and with the court coordinator, because it's set for something else today.
Yes, Your Honor.
Yes.
Sorry about that, Your Honor. I had to ask the lady to help me get back in the chat room, I guess.
No problem. Mr. Ortiz, what is happening with Mr. Talbot?
Your Honor, I believe we have an agreement on the defendant's motion for a PR bond.
Yes, what is the agreement?
The state does not object to a request for a PR bond as long as there is a condition for a GPS monitor. And we're in agreement with that condition.
All right, here's the thing, Mr. Talbot. The state and both parties are saying that they're in agreement with your request for a PR bond. Could you unmute yourself, please, for me?
Yes, Your Honor.
You need to make sure that you're available for all your hearings. If something ends up happening and you do not show up to court and there's not a good reason for you not showing up to court, then what's going to end up happening is I'm going to receive a request to revoke your bond. Do you understand?
Yes, Your Honor.
So you need to make sure that you appear for all of your cases, all right?
Yes, Your Honor.
And let me see which case I have you on. I have you on 086458. All right, Mr. Talbot, the questions that I'm going to ask you now, none of this is on the record, but I want to know because I want to make sure you have appropriate conditions. Are there any drug problems that you have that you need help with?
No, Your Honor, I think being in here was sufficient enough for me to stay away from whatever it was and
No,
realize.
I mean, Mr. Talbot, here's the thing. It's easy to stay away from things that you should stay away from if you don't have access to them. So is there going to be a drug issue with you?
No, Your Honor.
All right, I'll grant the PR bond. I'm going to waive the fees.
Your Honor, I think he has a misdemeanor, at least 1 or 2 misdemeanors in county court number 4.
My understanding is that County Court 4 has granted that.
Okay.
So we're saying GPS. State, what are you requesting with the GPS?
Just tracking, Judge.
Okay. All right, Mr. Talbot, now's the time to say it before I release you. If you have a drug or issue problem, they can help you with that. So do you have one or do you not have one?
I do not have any drug problems, Your Honor.
Okay. If there's nothing else, then that will be all.
Thank you, Judge Boyd. Thank you, Mr. Ortiz.
All right, you're welcome.
You're welcome, Mr. Talbot. Stay in contact with me, Mr. Talbot.
I will do, Mr. Ortiz. I will tell my dad and to help make sure that I stay in contact to do everything I'm supposed to.
Okay.
All right, Norma, can you let them know L3 can go back, please?
Am I be excused, Your Honor?
Yes.
Thank you.
Thank you for coming, Mr. Ortiz.
All right.
All right, David Garcia.
Good morning, Judge.
Good morning. What is happening
So,
with your case?
If you can put me in a breakout room with my client, Jesus Delgado, Judge.
Okay. Mr. Delgado, I'm going to send you to a breakout room with Mr. Garcia. He'll meet you in breakout room number 3.
Thanks, Judge.
You're welcome. Ken Baker, if I could see you, please. All right, we're going to recall your case at 1:30.
Man, I honestly, man, I didn't.
Okay, Judge, thank you.
Robbery was part of the deal.
All right, so your client needs to be back here by that time.
Thank you, Judge. Thank you. I will.
Sign, but I'll sign it again.
Okay.
Sure, no problem. And Todd McCray, I'll see you and your client back at 1:30.
Thank you,
Mr.
Judge. Have you ruled on the motion?
No, I have not ruled on the motion yet.
I wrote it down.
All right, but I'll see you back at 1:30, Mr. McCray.
Yes, Your Honor.
Your Honor,
All right, thank
before-
you.
Your Honor, before we do that, can we go into a breakout room?
Who wants to go into a breakout room?
Todd, yourself, and me, please.
All right, sure. Courtroom.
Room's being used right now in a breakout room.
All right, Mr. McCray, can you come back to the court's chambers, please?
Yes, Your Honor.
I can come down there if you want, Your Honor. It's up to you.
Oh, we can still do it by Zoom. We'll
Okay.
just Zoom from my office.
Oh, gotcha. Okay.
And so, Ms. McIntyre, I'll see you in breakout room number 1.
And Judge, I send you a chat.
Yes. Ms. Estrada, who's your attorney that you've hired? Could you unmute for me, please?
It was Daniel Rodriguez.
All right, we'll see if we can get Mr. Rodriguez here, okay?
Thank you, ma'am. Thank you.
You're welcome. Just give us a moment.
Sure.
Norma?
Yes, sir.
We have a deal worked out on Jesus Delgado.
Okay.
So I guess I need the certification and do we do a consent to plea by video?
Yeah. Yes, sir. I'll send it right over.
Awesome. Thanks, Norma.
You're welcome.
All right, anyone else ready? All right, I will check to see what email I have. Hi, someone's in there ready?
It's Hunter, Judge.
Ah,
You just have to stop, just press the button, make it turn green.
It's Hunter, Judge.
oh, hello, yes.
Hi, Judge.
Yes, hi.
So, I talked with Tom Nisbet, and we had a misunderstanding about what the plea agreement was, pretty fundamental. I need to discuss the issue with my client, and I'm asking for just a couple of days or a week for a reset I think we'll get it done. It's just that I gave some incorrect information to my client, and I think we need to have a sit down and discuss it.
Okay, and what is happening with the other brother, Monjares?
Well, it's a kind of a global deal. So I think both are going to need to be reset. But I mean, I don't think we need more than a week.
Well, I mean, can we come back on the 23rd?
Judge, I've got a docket in Comal and Guadalupe County, pretty extensive docket that day. I've got, if we could, can we do next Monday?
Are we able to do Friday?
Yeah, I can do Friday.
State, are you able to do Friday?
Yes, Judge.
We're going to come back on the 25th.
And will that be, can we do that by Zoom, Judge, or do we need to appear in person?
It can be by Zoom, but you need to make sure that the court coordinator has all of your client's email addresses.
I will forward those to her.
All right, we'll see you back on the 25th. Norma, is the 25th okay to do that?
Yes, ma'am, I'll make it happen.
All right, I'm sorry. I say it and then I ask for permission. So we'll see you all back then on the 25th on Monjares.
Thank you, Judge. I'll see you then.
All right, thank you. All right, Scott Martinez. My understanding is that your client has hired Dan Rodriguez.
Judge, it is Stephen Barrera is what I have listed on the C page, and it's only on one case, and Mr. Scott Martinez is still listed as the appointed attorney on the other case.
Okay, what case is, who's on what? That's my question.
On the injury, Stephen Barrera's on the injury, and on the burg is Scott.
All right, so the burglary of the habitation is the second degree. So that will take precedent anyway. So Norma, see if you can get that other attorney to zoom in here. My understanding that this is not a contested hearing, that it's a matter of me hearing some information so that I can make a ruling and that she will be pleading true.
Yes, ma'am, I'm trying to get a hold of him. But according to the defendant, I think she said that he knew about the court hearing.
All right, thank you. All right, everyone, let me know when you are ready. Norma, I'm sending you a chat.
Yes, ma'am.
Okay. Yes.
Norma, can you hear me?
Dan Rodriguez, I think
Yes.
there was maybe a mistake made. Do you represent Miss Estrada, Michelle Estrada?
Yes, Your Honor.
All right, so you were.
I was
you were-
hoping to, yeah, we were hired on that case.
All right, so I'm going to send you to breakout room number 1 with Scott Martinez. Scott Martinez, could you go to breakout room number 1, please? And Dan Rodriguez, if you could go to 1.
Thank you.
Oh. Norma? Can I see you in breakout room number 2?
Yes, ma'am.
And Hunter or Tom, can I see you in breakout room number 2, please?
But I can be here in the morning. That's not.
Yeah. David Garcia, you're back?
Yes, Judge.
Yes. What are we doing?
Oh, we have a deal worked out. I just need to check and see if my client has signed the paperwork. So if you can throw me into a room back with him.
All right, and who's your client?
It is Jesus Delgado.
Norma, for some reason, I don't see Jesus Delgado on the screen. Could you have them, have Mr. Delgado come back, please?
Yes, ma'am.
Thank you.
Ma'am, the officer's logging them in.
All right, thank you. All right, Mr. Delgado, I'm going to send you to breakout room number 1. Mr. Garcia, if you could go to 1.
Thanks, Judge.
You're welcome.
Talk to them. Do they want you in the breakout?
Hello?
Just a moment. Mr. Delgado, you need to go to breakout room number 1, please.
Yes, Your Honor.
Do you see at the bottom where there are 4 boxes or either something that says more? Thank you. And Norma, can you find out what is happening with Scott Martinez and Dan Rodriguez? Do you need to speak with Ms. Estrada?
Yes, please.
All right, Ms. Estrada, I'm going to send you to breakout room number 2 with your attorneys. And Rebecca, I'm signing the paperwork you sent me.
Thank you, ma'am.
You're welcome. Yes, David Garcia?
Yes, Judge.
Yes, has the paperwork been signed?
It has been signed. It should be already back at you guys.
All right, to the clerks, do you have the paperwork on Delgado, please?
It looks like I just received the video conference.
All right, there should be two together.
It is, it's all one package.
Give me 1 second, Judge.
Thank you.
Mhm. It's been signed, Judge.
All right. Well, David, as soon as that's brought to me, we'll take up your matter.
Sounds great, Judge. Thanks.
You're welcome. And Norman, can you check to see where David McLean is, please?
Yes, ma'am. Give me 1 second.
Thank you. Bye. Today is Monday. Yeah, but if everybody puts a smile on their face, it's going to be a beautiful day. Okay. All right, who are the prosecutors on Delgado?
It was Mr. Garcia, Judge.
All right, and who's the state's attorney?
No, the
Correct.
state attorney was Mr. Garcia.
Okay. All right, is everyone ready to proceed before we go on the record? All right, Mr. Delgado, can you unmute for me, please?
Yes, ma'am.
All right, the court is calling 2019 CR 5171, State of Texas versus Jesus Delgado. If I could have parties announced for the record, please, for the state,
Joe Ray Garcia for the state.
for the defense.
David A. Garcia for the defense, Your Honor.
And are you Mr. Delgado?
Yes, Your Honor, I am.
We're proceeding by video. Is there any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Delgado, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
The court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Delgado, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and states motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor, I did.
Are you the same Jesus Ricardo Delgado who was placed on deferred adjudication in 2019 CR 5171 for the offense of violation sex offender regular annual on August 5th, 2019 for a period of 3 years? Is that you?
Yes, Your Honor, I am.
State?
State's motion to supplement pending motion to enter adjudication of guilt and revoke probation violated condition number 5 in Bexar County, Texas. The defendant, Jesus Ricardo Delgado, did then and there fail to report to the supervision officer as directed for the months of April 2021 and May 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True, Your Honor.
State?
State waives the remaining allegations, Your Honor.
Any objections?
No objections, Your Honor.
Mr. Delgado, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor, I do.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor, I do.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge. The agreement is for revocation, adjudication, and a sentence term of 2 years TDC.
That is the agreement, Your Honor.
All right, Mr. Delgado, are you asking the court to follow that agreement?
Yes, Your Honor, I am.
Are you waiving your right to appeal?
Yes, Your Honor, I am.
All right, then the court will follow your agreement. The court is finding violation of condition number 5 true as previously stated. The court will grant the motion, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. Is there anything else from either side with regards to sentencing?
From the state.
None from the defense, Your Honor.
Next, Mr. Delgado, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Because you entered into a plea bargain agreement, because I followed that plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor, I do.
All right, with that, we'll close the record. Mr. Delgado, you could still be on deferred adjudication if you would just show up. You realize you have to register, correct?
Yes, Your Honor, I do.
All right, so you need to make sure you do that. Otherwise, you're going to find yourself in and out of prison. You understand?
Yes, Your Honor.
All right, Mr. Delgado, good luck to you. Have a great rest of your day.
Thank you. You as well, Your Honor.
Thank you. And Mr. Garcia, you're excused.
Thanks, Judge. Y'all have a great day.
All right, you too. Norma, can you let them know that 14M can go back?
Yes, ma'am.
All right, Mr. Beltran, we're waiting for your attorney, Eduardo Jimenez. Mr. Dash, we are waiting for your attorney, David McLean. But the court is going to take its afternoon break at noon. So Mr. Dash, Mr. Beltran, if your attorneys are not here before noon, we will come back at noon. I'm sorry, look, Brent, I'm saying we'll come back at noon. We'll come back at 1:30. Yes, Scott Martinez. And Dan Rodriguez, what's going on?
Just wanting to talk to the CLO if that was possible. Rebecca?
Yes, Rebecca, I'm going to send you to a breakout room with Dan Rodriguez and Scott Martinez. If Dan, if you can go to breakout room number 1.
Okay.
Scott Martinez, number 1, and Rebecca, you're already in 1.
Okay.
Judge?
Yes?
I believe Mr. Rodriguez is taking over the cases because, they were hired for the MTRs, not just
Okay.
one of them.
All right. Thank you, Mr. Martinez. Thanks for your patience. Have a great rest of your week.
No problem, Judge. You too. Thank you.
Thank you.
Judge, we only have notice on one case, so they need to file the notice on the other.
Okay. Norma, I'll send you to a breakout room with them if you can let them know, please.
Yes, ma'am. Judge, I sent you a chat.
Hey, Norma, are you there?
Yes, sir.
Okay, let me get the case file for you. Where did I put it? Here it is. Can we add on an inmate for just to confer with me and the defense lawyer tomorrow, please?
Yes, sir.
It's 2019
Oh.
CR 11890B.
All right.
And it's Orlando Castañon, and he knows already. I'm talking to him on text. Tomorrow is his preference.
Okay, in the morning or afternoon?
Morning's good. It's just me and him and the client in a breakout room for just a second, and then that'll be it.
Okay.
All right, Norma, I received your message. The client of Mr. McLean, we're going to bring you back at 1:30. Your attorney is in another courtroom and is currently not available. So Mr. Dash, we're going to bring you back at 1:30. Norma, can you let them know that 14B can go back and he'll be back at 1:30?
Yes, ma'am.
Thank you.
Judge,
Yes,
may I please have a breakout room with one of the trial division prosecutors, Tom or Marcus? I see Tom's
Oh.
available.
all right. You're in breakout room number 1. Could a prosecutor go to breakout room number 1, please?
Thank you.
You're welcome.
One, Judge?
Yes, please.
Yes, ma'am. Keep trying to send me to 2. Can you send me to
Okay,
1,
I don't,
please?
let me see what's going on. Ah, you're not the co-host. I've just made you co-host. So let me see where you are. I've sent you to 1.
Thank you.
You're welcome. And Mr. Beltran, we're going to bring you back at 1:30 as well. So Norman, can you let them
Yes,
know
ma'am.
that Mr. Beltran is excused until 1:30? He's 14L.
Yes, ma'am.
All right, thank you. All right, everyone, we're going to stop the live stream. We will be back at 1:30 p.m. Hopefully everyone has a great rest of your